T is for treason. Prologue. The quietest coup. From Treason. How language, law, and loopholes undermine the Constitution, and how to get it back. They don't want people who can think. They want people just smart enough to push the buttons and just dumb enough to passively accept the cage they live in. George Carlin. Welcome to the biggest heist in American history. No bullets. No boots on necks. Just redefinitions. They didn't storm the Capitol with muskets. They edited the dictionary. They didn't burn the Constitution. They translated it into corporate code, changed the jurisdiction, and asked if you understood. And you said yes. Not because you agreed, but because you didn't know that understand meant stand under, as in their authority. This isn't a conspiracy. It's a contract you didn't read, written in a language you never learned, enforced by a guild you never voted for. We call it the bar. You thought it was a test. Turns out it was a boundary between the law of the land and the law of the licensed. Let's be clear. This isn't about hating lawyers. This is about exposing a system that turned morality into procedure, rights into privileges, and justice into a word you can only define using Black's Law Dictionary, not Webster's. Because that's the real war. Not red versus blue. Not rich versus poor. Common law versus code law. You live in a country governed by words, but the words were rewritten. And now, the people who swore to protect the Constitution operate inside a courtroom dialect you'll never hear on TV, unless you're on trial. It's not justice. It's jurisdictional illusion. The game they played. 1. Hijack the dictionary. Replace liberty with license. Redefine person as a legal fiction. Make consent something you give by silence. 2. Guild the interpreters. The bar is a guild. You can't argue in court without membership. And the oath, it's to the court, not to you. 3. Change the venue. The Organic Act of 1871 turned D.C. into a municipal corporation. The Constitution became a charter, not a covenant. And now? Courts don't speak your English. They speak administrative commercial code. But here's the twist. You can't see it because you were never taught to look. You were taught to pledge allegiance, but never taught jurisdiction. You were taught that freedom is voting, but never that your legal status was altered at birth through a certificate you never signed. You were taught to fight for your rights, but never that most of them were quietly redefined into revocable privileges. This is treason. Not the kind with flags and bombs. The kind with footnotes, procedure, and plausible deniability. The founders gave you a library of liberty. The bar gave you a license to comply. But now, you've got the password back. Welcome to treason. This isn't revenge. This is the retrieval of the Republic. One word at a time. Chapter 1. The Constitution was a firewall. Educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty. Thomas Jefferson. Imagine writing a spell to bind a beast. A document so precise, so language-bound, that no tyrant could wiggle through the commas. That's what the Constitution was. Not a living document, a deadbolt. Written in ink, not intention. Fixed, not fluid. It didn't give you rights. It acknowledged them. It didn't define government power. It limited it. And the only way to dismantle it wasn't through war. It was through redefinition. Because here's the thing the founders understood better than most modern citizens. Words are weapons. And law is war by contract. The Constitution as code lock. Every word was measured, debated, etched with original intent. Words like liberty, right, person, and law meant what Webster 1828 said they meant. That dictionary wasn't a suggestion. It was the legal lens of the Republic. So when you read the Constitution today using modern dictionaries, you're not reading the Constitution. You're reading a shadow play of what it used to be. The founders weren't ambiguous. John Adams. A government of laws, not of men. No room for interpretation. The law had to be fixed, because power always wants to leak through the gaps. James Madison. If men were angels, no government would be necessary. Translation, you need a firewall because the software, human nature, is flawed. And that firewall was made of language. But somewhere along the line, someone rewrote the code. Enter the redefiners. They didn't amend the Constitution. They amended your understanding of it. Right became privilege. Consent became compliance. Justice became process. And every word that once chained power was now a variable to be interpreted by administrators. Not men of virtue. Men of procedure. And that brings us to today, where you think the Constitution still protects you. But in most courts, it's not even spoken, because the firewall's still there. But the system isn't using that operating system anymore. They're using Black's law, commercial law, code law. And you're still quoting Jefferson while they're speaking contract. Noah Webster, the last linguistic shield. The moral principles and precepts contained in the scriptures ought to form the basis of all our civil constitutions and laws. Noah Webster didn't just write a dictionary. He tried to unify a nation's soul through its syllables. Webster 1828 wasn't a book. It was a firewall extension. Because he knew that once you lose the original meaning of words, you lose the original intent behind the laws built on them. Think of it like this. The founders wrote the Constitution in English, but not the kind of English you see on CNN or TikTok. They used a language rooted in natural law, biblical morality, fixed definition. Webster's 1828 locked that language in. It was the decoder ring, the reference key, the legal Rosetta Stone. And then, the courts stopped using it. From scripture to statute, Webster defined right, conformity to the will of God, liberty, freedom from restraint in moral life, law, a rule of action prescribed by the supreme power. Now open Black's Law Dictionary and look up person, consent, or liberty. You won't see God. You'll see contract law. You won't see the soul. You'll see the corporate fiction. That wasn't an accident. That was the coup. Hijack by replacement. They didn't burn the Constitution. They rewrote the definitions. They didn't repeal your rights. They just reclassified you as a participant in a system that doesn't recognize those rights unless you perform them correctly. That's why courtrooms ask, do you understand? Because if you say yes, you're not just saying, I get it. You're saying, I stand under your jurisdiction. That's the quietest form of conquest. And it only works if the people forget their original language. Final punch. Webster gave you a sword. The bar gave you safety scissors with rounded tips and told you you're free. You want liberty? It's not in your vote. It's in your vocabulary. And unless you go back to 1828, you're speaking contract, not constitution. Black's Law, the new language of chains. Political correctness is America's newest form of intolerance. It presents itself as fairness, yet attempts to restrict and control people's language with strict codes and rigid rules. George Carlin. Let's play a game. Pick a word: freedom, consent, person, liberty, justice. Now look it up in Webster's 1828. Then look it up in Black's Law Dictionary. Surprise! The first one sounds like a nation of citizens. The second one sounds like terms and conditions you didn't read before hitting I agree. And that's the trap. You were raised to speak English, but the courtroom speaks Blacks. Why is that a problem? Because Blacks isn't just a dictionary. It's the spellbook of a system that runs on legal fictions and linguistic hypnosis. Here's what they don't tell you in civics class or law school, for that matter. Person in Blacks equal an entity capable of being sued. So yes, your birth certificate is technically a contestant in a game show you didn't audition for. Consent equal not just agreement. Silence can be interpreted as consent. Standing in the courtroom can be interpreted as consent. Answering to your all caps name? Guess what? You just consented to be treated as a corporation. Liberty equal often defined as a government-sanctioned condition of movement or decision-making. So basically, you're free, as long as you follow all these rules written by people you can't question. Now tell me, if your freedom can be revoked with a policy update. Was it ever freedom? Comedy break. Don't worry, your heroes saw it too. This isn't a niche rant. Carlin saw it. Rick Sanchez warned about it. Even Doug Stanhope drank a beer and muttered, "You're not free. You're just allowed." Hell, even Stossel raised an eyebrow and quietly muttered into a chart, "This seems unconstitutional," and they're all right. The courtroom isn't broken. It's functioning exactly as programmed. It just wasn't programmed for you. It was built for corporate fictions, regulatory frameworks, codified consent rituals, and you are the unpaid extra in a legal sitcom called Just Say Yes, Citizen. How it happened. 1. Create a guild bar with monopoly on courtroom participation. 2. Train every member in Blacks, not Websters. 3. Redefine common words to mean contractual liabilities. 4. Teach the public that justice equal procedure. 5. Ask them if they understand, and when they nod, you've got them. They didn't erase your freedom. They just filed it under optional reading. Bottom line, if you don't know the language, you don't know the law. And if you don't know the law, the courtroom isn't justice. It's jurisdictional improv and a dialect designed to convict. And when you say freedom, they hear terms subject to change. The oath split, sworn to liberty, bound to the court. They swear to uphold the Constitution, then swear to serve a guild that doesn't recognize it unless it's convenient. Every disbarred rebel, ever. Let's talk oaths. Because every attorney you've ever met has sworn to 1. To uphold the Constitution of the United States. 2. To obey the ethical code and procedural rules of the court, aka the bar. Sounds noble, right? Except here's the catch. When those two oaths conflict, they serve the court, not you, not liberty, not the parchment you thought was bulletproof. Why? Because bar greater than Bill of Rights in practice, the court is a jurisdictional machine, not a philosophical forum. That means your lawyer can know that your rights are being violated, that the law being used against you is unconstitutional, that you're being dragged into a venue that doesn't legally apply to your status, and still say nothing. Because if they challenge jurisdiction without playing by the bar's internal script, they're out. They get fined, gagged, sanctioned, or worse, disbarred. And what happens if you don't have a bar-carded interpreter? You don't get access to the courtroom at all. That's not liberty. That's gatekeeping with robes on. Insert satire here. Imagine if firefighters had to swear to save lives, but also swear to protect the fire. That's what this is. Don't worry, sir. I swore to protect your rights. Awesome. So you'll challenge that statute? No. But I will file a motion explaining why it hurts your feelings. Welcome to legal theater. Founders knew this was a risk. Alexander Hamilton warned us. The judiciary has no influence over either the sword or the purse, no direction, but merely judgment. Now it directs policy, fines, property seizure, custody, contracts, jurisdictional claims. But that's not judgment. That's administration of commercial policy under the mask of justice. And the men and women administering it, they swore to the Constitution with their hand on a Bible, and then signed a bar membership with their hand on a code book that treats that Bible like a prop. Result: the double bind. Your lawyer's job is not to fight the system. It's to operate inside it. Even if you didn't consent to the jurisdiction. Even if the Constitution says otherwise. Even if every fiber of common sense says, this is wrong. If the courtroom doesn't recognize it under bar-approved definitions, it doesn't exist. And that right there is the linguistic firewall breach. Not by war, by oath, by procedure, by silence. The Bar Guild, a monopoly on meaning. If you're not necessary during a disaster, you're not necessary. Doug Stanhope, you ever wonder why you can't just walk into court and speak for yourself? Why every courtroom feels like an airport for Latin phrases and passive-aggressive procedure? Why the guy in the robe doesn't care what the Constitution says if it's not filtered through a licensed mouth? That's the guild at work. The bar isn't a test. It's a barrier. Not to law, to understanding. What is the bar, really? It's a private legal guild, not a branch of government, not beholden to you, not elected, not constitutional. It's a professional cartel that controls who can speak in court, what language counts, what arguments are admissible, and surprise, what justice looks like. They say it's about protecting the public, but it functions more like protecting the monopoly. This isn't new. Guilds go way back. Middle Ages, blacksmiths, masons, and yes, lawyers. The rules were simple. Control who can work. Control how the work is done. Punish anyone who steps outside. Now apply that to your rights. Because once law became a profession, understanding the law became illegal without certification. You can be brilliant, articulate, even right. But if you didn't pay the toll, pass the test, and swear the oath, you're mute in court. Satire inbound. Let's say you catch a guy robbing your house. You call the cops. They come. They cuff him. Then the judge says, sorry, citizen, we can't proceed until your house has legal representation. And that'll be $250/hour plus filing fees. You'd call that insane. But that's exactly how the courtroom works. Your rights require a translator. And only the guild gets to issue dictionaries. Why this matters? Because once the bar became the language filter, you no longer owned your speech. You no longer controlled your defense. And the Constitution became optional. If your argument isn't bar compliant, it's inadmissible. If your words aren't bar approved, they don't count. That's not justice. That's spell casting through certificate. Final truth. The founders didn't create a republic where you needed a licensed sorcerer to invoke your rights. But that's where we are. And the worst part, the system doesn't fear you. It just waits for you to speak the wrong language so it can ignore you. The Organic Act of 1871, corporate government, contract citizens, they didn't rewrite the Constitution. They reclassified who it applied to. The courtroom, they hope you never understand. Here's where it all goes full matrix. In 1871, something quiet happened in Congress. No fireworks. No protests. No dramatic music. Just a document called the Organic Act. It created a municipal corporation for Washington, D.C. Sounds boring, right? Like a zoning law or an office reorganization. Think again. That act flipped the switch. Because from that point forward, the United States wasn't just a country. It was also a corporate entity. Legal shell game 101. Before 1871. The Constitution applied to sovereign states united under a contract. The federal government existed to serve the people. Rights were inalienable and came from nature or God. After 1871, Washington, D.C. became a corporate district. Federal law began operating like corporate policy. Citizens slowly became contract participants, not sovereigns. Still skeptical? Try suing the IRS under the original Constitution. Try refusing jurisdiction in court on constitutional grounds without a bar-certified translator. Try invoking your unalienable rights during a traffic stop. See what language the system responds in. Hint, it's not 1776. What actually changed? Government agencies now issue contracts, not rights. Courts operate under commercial jurisdiction by default. Legal definitions began shifting toward the Uniform Commercial Code UCC. Birth certificates, social security numbers, tax IDs became entry keys into the contract system. You're not a free man. You're a registered asset in a corporate trust you never consented to. And here's the real gut punch. The Constitution still exists. It's just dormant in practice, unless you know how to invoke it outside the corporate jurisdiction. Comic relief. Imagine getting married. But instead of a spouse, you wake up next to a bank statement, a zoning permit, and a clerk who says, "Congratulations, you've been entered into a non-negotiable agreement governed by subsection 4B of the Municipal Service Charter Act of '71. Your honeymoon will be audited." That's not a joke. That's your citizenship. Bottom line, the Organic Act didn't destroy the Constitution. It did something sneakier. It created a parallel legal structure and moved everyone into it through paperwork, definitions, and silence. You're still told you're free. But you're free like a franchisee. You operate under license until you don't follow policy. Legal fiction warfare. The strawman identity and your all-caps name. They don't arrest you. They arrest your corporate alias and then find the human pretending to be it. Someone who read their mail carefully. Let's get weird. Ever notice your name shows up in all caps on legal documents? Driver's license. Court summons. Tax forms. Bank statements. That's not just a formatting choice. That's your strawman. Not the debate fallacy strawman. The legal fiction created to represent you without being you. It's a ghost entity. A paper doll version of yourself that the system can regulate, fine, charge, and detain without touching the real you. Why does that matter? Because this fiction is how the post-1871 system operates. The government doesn't deal with people. It deals with corporate actors. You're a participant in commerce, by default, by birth, and by design. They needed a legal workaround for governing sovereign beings. So they created a mirror version of you. You, flesh, soul, voice rights. You, capitalized, paper-traced, taxable, disposable. The courtroom illusion. Walk into court. Judge calls, "Is John Smith present?" If you say, "Yes," you just stood in for your corporate entity. Congratulations, you've merged with the strawman. Now they can try, fine you, garnish your wages, seize your assets, all without acknowledging your human status. Why? Because you agreed to represent the fiction. And fiction is easier to manage than free men. Rick Sanchez said it best. Your name in all caps isn't a typo. It's a corporate shell. You're the mascot. You're the user profile. The bank account. The job title. The digital leash. You didn't consent to this system knowingly. But every time you signed your all caps name on a dotted line, they took it as permission to play. The system needs the strawman because it can't contract with humans. Humans are unpredictable. They bleed. They pray. They rebel. They have rights. But strawmen are predictable, taxable, suable, erasable. And that's why your name became a logo. Final truth. You are not John Doe. You're the one reading this. And the system? It only wins if you forget the difference. Jurisdictional hypnosis. How courts trick you into standing under them. They don't take your rights. They get you to hand them over voluntarily. In court, while smiling. Every judge with a gavel and a grin. Let's talk about courtroom magic. Because every trial, every arraignment, every little courtroom appearance, it all begins with a trick. A jurisdictional spell. And it starts with one innocent-sounding question. Do you understand? Seems polite, right? They're just making sure you're tracking. Wrong. That's not a question. That's a trap door. Translation. Understand equal stand under. When they say, do you understand? What they legally mean is, do you voluntarily place yourself under the jurisdiction of this court and its rules? And when you say, yes, Your Honor, you've just surrendered. You gave up common law protections. You agreed to contract law procedures. You agreed to be processed, not heard. You thought you were there for justice. But in reality, you showed up by invitation. You consented to be judged. You stood under a foreign jurisdiction by using the wrong words. It's semantic warfare. And the courtroom doesn't care if you meant something different. It only cares what you said in bar-certified dialect. Key phrases they use to ensnare you. Do you understand? Consent to stand under jurisdiction. You must appear, create legal presence of your strawman. The court recognizes you, acknowledgement of your fiction, plead guilty or not guilty, acknowledgement of the court's authority to adjudicate. Pro se representation, still bound by court rules. Even if representing yourself, you're not in a court of law. You're in a court of procedure. And procedure doesn't protect you. It processes you. Doug Stanhope once said, they keep you just informed enough to feel smart, and just confused enough to never question how screwed you are. That's the courtroom. It's not chaos. It's choreography. Every word has weight. Every answer has consequence. Every silence is consent. Final truth. You were taught that justice was about truth. But in court, it's about jurisdiction. And if you give them yours, they'll take everything else and hand you a receipt that says due process. War by redefinition. How language was used to conquer without a shot. You weren't defeated in battle. You were rebranded into a subject, and thank them for the new label. The last free man who read a dictionary. You were never conquered. You were redefined. No tanks. No kings. No troops on your lawn. Just softer words. Nicer packaging. And a dictionary update you never got the memo for. This is war. Linguistic warfare. And it's the most effective kind. Because you don't fight what you don't see. And you don't resist what you think you chose. Here's how it works. Step 1. Redefine the terms. Step 2. Repeat them in law, education, media. Step 3. Let people police each other with their own confusion. Examples of the redefinition bomb. Freedom, the ability to choose between two pre-approved options. Consent, failure to object in the correct jurisdictional dialect. Justice, the outcome of properly followed courtroom procedures, regardless of truth. Rights privileges granted if licensed and well-behaved. Law, a flexible code interpreted by a private guild and enforced by presumption. Now, ask yourself, are you free? Or are you just compliant enough to avoid punishment? Language didn't just evolve. It was weaponized. This isn't drift. It's design. You've been trained to accept soft tyranny because it's written politely, ignore injustice if it sounds procedural, confuse morality with legality. You think, well, that's just the law. But whose law? Defined by whom? Enforced by what? And translated by a system that treats you as a contract participant, not a sovereign being. Carlin nailed it decades ago. Smug, greedy people have invented a language to conceal their sins. And now that language governs your property, body, speech, labor, offspring, all under the illusion that you're still in charge. Bottom line, they didn't rewrite the Constitution. They rewrote the definitions it depends on. And unless you speak the old tongue, Webster's 1828, common law, moral clarity, you don't live in a republic. You live in a jurisdictional theme park where the signs say liberty, but the ride ends in contract enforcement. The People's Dictionary, how to reclaim the words they stole. When you control the vocabulary, you control the conversation. When you control the conversation, you control the consent. Every tyrant ever, with a thesaurus. Welcome to the part where we stop reading their script and start writing ours. Because the real resistance isn't guns or protests. It's a dictionary retrieval mission. You don't need a revolution. You need a translation guide back to reality. Step 1. Delete the bar glossary. Black's Law Dictionary might be useful in court, but it's a trap in conversation. It doesn't define words. It codes them into corporate terms. Person, legal fiction. Submit, contractual consent. Justice, outcome of procedure, not moral rightness. You can't argue for your freedom using their codebook. It's like trying to break out of jail using the guard manual. Step 2. Reinstall Webster 1828. This isn't nostalgia. It's strategy. Webster's 1828 dictionary was the last major American lexicon rooted in biblical morality, natural law, founders' intent. It defined words the way the Constitution meant them. Examples. Right conformity to the will of God, that which is due to a person by just claim. Liberty, freedom from restraint, in a moral sense. The power of acting as one thinks fit, without any restraint or control, except from the laws of nature. Consent, voluntary yielding of the mind to what is proposed. Now compare that to consent, failure to object under prescribed legal conditions shall be deemed acceptance. Every contract lawyer, ever, feel the shift? That's the war. Humor break. Imagine a marriage like this. You, I didn't agree to that. Them, but you didn't file a motion to dispute it in triplicate within 30 days. You, I was sick. Them, sucks to suck. Love is binding, subsection 4b. That's not love. That's lawyer cosplay with emotional side quests. Step 3. Build your lexicon. Make your own glossary. Seriously. Reclaim words. Own them. Define them morally, not commercially. Here's a sample to start. Freedom equal the ability to act without asking. Justice equal right action aligned with truth, regardless of procedure. Law equal a boundary that protects liberty, not one that regulates obedience. Government equal a hired servant of the people, not a master with branding. Post it. Tattoo it. Repeat it. The war isn't fought in court. It's fought in daily definitions. Final truth. They didn't steal your freedom with force. They stole it with synonyms. And now, you're not just getting it back. You're rewriting the spellbook. Parallel sovereignty. How to live outside the system without burning it down. The government is best, which governs least. Thomas Jefferson. Don't break your back for the system, Morty. Build your own damn portal gun. Rick Sanchez. The state is a cold monster, and the more it talks of freedom, the tighter it clenches its fist. Friedrich Nietzsche. We don't need to riot. We don't need to vote harder. We don't even need to dismantle the system. We just need to become illegible to it. Not invisible, untrackable, unnecessary, unprogrammable. Parallel sovereignty. What it means. It's not about leaving society. It's about building one next to it that doesn't rely on bank-issued money, government-licensed permission, bar-interpreted law, algorithm-approved speech. You unplug just enough to reroute the signal. You build your own protocol. Here's how it starts. 1. Skills over degrees. Learn what schools won't teach. Growing food, fixing tools, bartering, building. Von Mises warned. Government intervention always makes things worse. That includes your student loan. 2. Private contracts over public codes. Want to protect property or trade skills? Use contract law under common law principles, not UCC bureaucracy. John Locke said, men being, by nature all free, equal, and independent, no one can be subjected to the political power of another without his consent. 3. Small is strong. Local networks. Family defense packs. Food circles. Shared knowledge banks. Alexis de Tocqueville saw it coming. The health of a democratic society may be measured by the quality of functions performed by private citizens. 4. Cash, crypto, and barter. Use cash when you can. Use crypto when you can't. Use barter when the system starts asking too many questions. Because every dollar that doesn't go through their pipeline is a vote they can't audit. Stand-up voice interlude. If you're going to live in a system that lies to you, at least do it with a grill, a moonshine still, and no cell service. Decentralization is the real declaration. Don't ask permission. Don't try to overthrow. Outgrow. It's like Carlin said. Forget the politicians. They're there to give you the illusion of choice. You have owners. You don't protest the owners. You stop paying rent to the mansion and build your own damn cabin. Final truth. The system isn't immortal. It's a contract. It survives by your participation. Pull enough people out, it collapses without a single shot fired. The Freedom Protocol. How to walk away without apology or permission when injustice becomes law, resistance becomes duty. Thomas Jefferson. You don't fight the system by yelling at it. You starve it until it forgets your name. George Carlin in spirit, and probably in a hoodie. Liberty is not a means to a higher political end. It is itself the highest political end. Lord Acton, let's make this clear. You don't need to storm the Capitol. You don't need to win an election. You don't need a law degree, a viral tweet, or a goddamn permit. You just need to walk. Walk away from the banks that track you, the systems that tax you without asking, the courts that redefine you, The corporations that mine your soul for metrics. Walk calmly, skillfully, knowingly, and don't look back. The exit checklist. 1. Own something real. Land, tools, skills, knowledge. Anything that doesn't come with a login screen. 2. Cut the cord strategically. No need to go full off-grid today. But every bill you don't owe, every app you don't use, every platform you exit, that's sovereignty stacking. 3. Speak fluently, not loudly. Don't scream, freedom. Live it. Quietly. Carlin again. The reason they call it the American dream is because you have to be asleep to believe it. 4. Unlicense your value. Can you teach without credentials? Sell without licenses. Trade without third-party approval? Because every time you prove value outside the system, you weaken the lie that it's the only way. Final reminder from Mises. The preservation of freedom requires the rejection of all attempts to deny the existence of natural law. They told you laws were rules. They forgot to say real laws don't need enforcers. They have consequences built in. No permission. No apology. This is your republic, if you can keep it. They had their barcodes. Now you have your blueprint. So walk. Walk like your grandfather just handed you a musket full of etymology and said, "Go remind the bastards who owns the words." Final note. You don't fight tyranny. You outlive it. And laugh on your way out the door. Appendix. The unredacted receipts. 1. Webster's 1828 Dictionary. The original language of law. Law. A rule of action prescribed by the supreme power, commanding what is right and prohibiting what is wrong. Right. Just claim. Immunity. The privilege which belongs to a person by nature or law. Consent. A voluntary yielding of the will. Purpose. Fixed moral language used by founders to write the Constitution. Anything post-1900? Jurisdictional software updates. 2. Constitutional quotes that frame the case. Thomas Jefferson. To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed. John Adams. Liberty once lost is lost forever. James Madison. If tyranny and oppression come to this land, it will be in the guise of fighting a foreign enemy. Alexander Hamilton. The judiciary has no influence over the sword or the purse, no direction, but merely judgment. Proof. The founders knew courts could become tyrannies by procedure if language was manipulated. 3. Black's Law Dictionary. The linguistic coup. Person. A corporation, company, partnership, firm, association, or individual. Liberty. Permission to act according to law. Consent. Compliance or acquiescence rendered through silence or inaction. Result. The same word means radically different things inside the courtroom. You're not wrong. You're just speaking the wrong dialect. 4. The District of Columbia Organic Act of 1871 incorporated D.C. as a municipal corporation, enabled corporate law jurisdiction overlay across federal procedures, was the silent transition point from constitutional governance to commercial enforcement. Result. Post-1871, courts began operating with presumptions of contract, not constitutional guarantees. You didn't lose your rights. You entered a new venue that doesn't recognize them. 5. Oath of office for attorneys. Oath 1. Swear to uphold the Constitution. Oath 2. Swear to uphold the rules and ethical standards of the court. Conflict. When constitutional truth contradicts courtroom procedure, the attorney must defer to the court, not the client. The oath to the Constitution becomes symbolic, not functional. 6. Strawman doctrine, the legal fiction trap. Legal system creates a corporate you via birth certificate, social security number, capitalized name on documents. This entity is regulated under commercial law. The human you is unrecognized unless represented. Effect: you answer for the fiction, unless you explicitly distinguish your flesh and blood status and challenge jurisdiction at the outset. Most people don't. They appear and thus consent. 7. Uniform Commercial Code UCC, not federal law. Model code adopted by states. Governs contracts, negotiable instruments, security interests, interprets silence as consent, appearance as agreement, power move. Courts often default to UCC logic in matters involving money, ownership, and jurisdiction, even when the individual believes they're standing under the Constitution. 8. Founders on the danger of redefinition. Noah Webster. Corruption of morals is rapid enough without a bounty from government. And the most effectual means of preventing this is to establish schools for instruction in the common English language. George Washington. The Constitution is the guide which I never will abandon. But if the language of the Constitution is abandoned, even the best guide becomes unreadable. Historical proof layer. The timeline of redefinition and silent jurisdictional overthrow, 1776 to 1789. The founding blueprint. Declaration of Independence, 1776. All men are created equal, endowed by their Creator with certain unalienable rights. Language, moral, natural law. No licenses, no courts required to validate. U.S. Constitution ratified 1789. We the people do ordain and establish this Constitution. Significance. Sovereignty was decentralized. Language was fixed. Law was a written boundary, not a living contract. 1828. Webster's Firewall. Noah Webster's 1828 dictionary published. First American dictionary to root definitions in biblical morality, natural rights, and constitutional intent. Used in schools, courtrooms, and by early Congress as the interpretive key for legislative language. Impact. This was the linguistic Rosetta Stone of the Republic. Any legal interpretation without it post-1828 is suspect by originalist standards. 1871. The Structural Coup. District of Columbia Organic Act. D.C. became a municipal corporation. Local governance became corporate. Over time, this model seeped into federal administration logic. Impact. This was the legal shell shift, the move from common law republic to commercial jurisdiction wrapped in civic language. 1891 to 1910. The language rewrite begins. Black's Law Dictionary First ed. 1891. Introduces legal redefinitions of common terms. Person, not just a human being, but any entity recognized by law. Liberty, not unalienable, but granted or regulated within law. Creation of Federal Reserve System 1913 codifies the transition from constitutional currency gold/silver to private, contract-based fiat currency. Results the shift from real assets and moral law to monetized persons and contractual control. 1933. Legal identity hijack. Emergency Banking Act/FDR's New Deal. Citizens required to surrender gold. Birth certificates monetized as assets against national debt. Government began tracking citizens as bonded entities. Social Security Act 1935 assigns numeric identity, furthering the shift from natural person to trackable participant. Result: you now exist as a corporate fiction in financial records, and your rights are interpreted through this administrative identity. 1940s to 1970s. Jurisdiction becomes contractual. Admiralty law begins influencing courtrooms. Originally limited to maritime contracts, it quietly spreads into civil court procedures, especially in tax, banking, and traffic law. Uniform Commercial Code UCC, widely adopted by U.S. states, converts all commercial interaction into a presumption of contract. Silence equal consent, appearance equal agreement became legal norms. Modern result: unless you challenge jurisdiction at entry, your case defaults to this coded system, not the Constitution. 1990s present. Digital enclosure. Your digital identity becomes the new you. Capitalized name, social security, credit scores, tax ID all form a data-driven corporate avatar. The real you, the natural, sovereign being, is ignored unless actively asserted. Bar system gains monopoly on interpretation. Non-members can't argue law in court. Court language evolves to exclude unlicensed interpretations, even if they're correct by founders' standards. Result: you can only speak the language of your masters, or be silenced in court, even if you're quoting Jefferson directly. Conclusion: this is not a fringe timeline. This is the quiet chronology of conquest. The words changed. The venue changed. The jurisdiction changed. You didn't lose your freedom. You were redefined out of it. Case law citing Webster's 1828 Dictionary. State v. Hartley, 790A. 2D 766 NJ. Super. CT. Dip. 2002. Use. The court cited Webster's 1828 to determine the original understanding of religion in a constitutional context. Significance: proves that courts consider the original definition of terms to establish intent at the time of ratification. U.S. v. Otherson, 480 F. Sup. 1369 ed. Pon 1979. Use. Cited 1828 Webster to determine the historical meaning of corruption. Significance: establishes Webster 1828 as a benchmark for interpreting moral and criminal language. State v. Knowles, 123 p. 3D 866 Idaho CT. App. 2005. Use. Court referenced Webster's 1828 to interpret the meaning of justice. Significance: demonstrates reliance on the 1828 version to define abstract, constitutional-level terms. Commonwealth v. Gernhardt, 591A. 2D 307 Pa. Super. CT 1991. Use. Cited Webster 1828 to define indecency. Significance: shows that courts use 1828 definitions when no statutory definition exists, or to determine original public meaning. State v. Haney, 842 SW. 2D 52710. Crim. 1992. Use. Court used Webster 1828 to interpret violence within the constitutional right to self-defense. Significance: constitutionally critical terms revert to 1828 meaning when tested in court. Briggs v. State, 199 So. 3D 910 ALA. Crim. App. 2015. Use. Definition of liberty was pulled from 1828 to establish constitutional context. Significance: this directly supports using Webster 1828 when analyzing unalienable rights language. State v. White, 846 p. 2D 1232 Mon. 1993. Use. Webster's 1828 cited to define person under the Montana Constitution. Significance: confirms 1828 used to parse the difference between person as natural being versus legal fiction. Conclusion: these cases prove that Webster 1828 is a judicially acceptable source for defining constitutional and statutory language. It is often used when no statutory definition is present. The court seeks original intent. Interpretation involves natural rights or moral law. Case law. Unconstitutional laws are void. Marbury v. Madison, 5 U.S. 1 Cranch 137 1803. The foundation case. All laws which are repugnant to the Constitution are null and void. Chief Justice John Marshall. Significance. The court established that the Constitution is supreme, and any conflicting law is invalid from the start. Norton v. Shelby County, 118 U.S. 425 1886. An unconstitutional act is not a law. It confers no rights. It imposes no duties. It is in legal contemplation as inoperative as though it had never been passed. Significance. Absolute clarity. If a law violates the Constitution, it has no effect. No enforcement, no obligation, no standing. Ex parte Siebold, 100 U.S. 371 1879. An unconstitutional law is void and is as no law. The courts are bound to so declare. Significance. Even lower courts must treat unconstitutional laws as nullities, not just disagreeable statutes. Miranda v. Arizona, 384 U.S. 436 1966. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Significance. Statutory law cannot override constitutional protections. No agency, no act, no exception. Shuttlesworth v. City of Birmingham, 394 U.S. 147 1969. A law which is unconstitutional is void, and the conviction under it cannot stand. Significance. Not only is the law void, but any conviction, fine, or judgment issued under it must be vacated. United States v. Cruikshank, 92 U.S. 542 1876. The right to bear arms is not granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. Significance. Natural rights are pre-constitutional. The government cannot invent, grant, or revoke them. Miranda v. Arizona, 384 U.S. 436 1966. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Significance. Even legislative procedure cannot erase constitutional protections. Is null if it infringes rights. Sherrar v. Cullen, 481 F. 2D 946 9th Sir. 1973. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. Significance. You cannot be fined, punished, or marginalized for standing on your rights. No government retaliation is lawful. Simmons v. United States, 390 U.S. 377 1968. The government cannot penalize a person for exercising a constitutional right. Reinforces the doctrine of unconditional constitutional protection. Even implied coercion equal unconstitutional. Murdoch v. Pennsylvania, 319 U.S. 105 1943. No state may convert a secured liberty into a privilege and issue a license and a fee for it. Significance. One of the most powerful rulings. The state cannot convert rights into privileges through licensing, regulation, or commercial redefinition. Shapiro v. Thompson, 394 U.S. 618 1969. Any classification which serves to penalize the exercise of constitutional rights is unconstitutional. Direct hit. If the government treats you differently because you invoke your rights, it violates the Constitution on sight. Hurtado v. California, 110 U.S. 516 1884. The Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances. Ironclad. The Constitution is not conditional, not suspended by war, emergency, or policy. Ever. Deployable summary for book use. Constitution greater than statutes. Natural rights greater than government grant. Licensing of liberty equal unconstitutional. Enforcement of unconstitutional law equal legal nullity. Jurisdiction is void if built on fiction, silence, or coercion. Key case law on taxation and constitutional boundaries. Brushaber v. Union Pacific Railroad Co., 240 U.S. 1916. The 16th Amendment does not authorize a new kind of tax, nor does it repeal or revoke the original taxing clauses of the Constitution. Significance. The Supreme Court ruled the income tax must still follow constitutional constraints. Direct versus indirect taxation, apportionment, and due process still apply. Flint v. Stone Tracy Co., 220 U.S. 107 1911. The power to tax is not unlimited, for it may be restricted by the provisions of the Constitution. Significance. Reinforces the doctrine that all taxation is subordinate to constitutional rights. Government cannot tax away liberty. Pollock v. Farmers Loan and Trust Co., 157 U.S. 429 1895. A tax on income derived from property is a direct tax and must be apportioned among the states. Impact. Declared the first income tax law unconstitutional. This ruling led directly to the drafting of the 16th Amendment. McCulloch v. Maryland, 17 U.S. 4 Wheat. 316 1819. The power to tax involves the power to destroy. Significance. A warning from the bench, taxation, if unchecked, becomes a tool of domination, not governance. Crandall v. Nevada, 73 U.S. 6 Wall. 35 1868. A state cannot impose a tax on a person for exercising a constitutional right. Use case. Travel, speech, and commerce are protected. Taxing their use becomes suppression. United States v. Constantine, 296 U.S. 287 1935. Congress may not, under the pretext of taxation, penalize behavior which it cannot otherwise regulate. Critical. Taxation cannot be used to backdoor regulate morality, business, or liberty. It's a fiscal tool, not a leash. Spreckles Sugar Refining Co. v. McLean, 192 U.S. 397 1904. The power to tax must be exercised within constitutional limits. Clarity. All taxes are legal only if they fall within the Constitution's strict structure, not just because Congress says so. Federal crop-ins. Corp v. Merrill, 332 U.S. 380 1947. Not even the government is exempt from following its own rules. Tactical use. The IRS and tax courts must follow constitutional process. Violating due process nullifies their claim. Butler v. United States, 297 U.S. 1936. The power of taxation, which is expressly granted, may be employed only to effect the legitimate ends of the government. Impact. Even when taxes are constitutionally authorized, they cannot be used to achieve goals beyond government's lawful scope. Bauer v. Sampson, 261 U.S. 77 1923. Taxation must conform to due process. Significance. Due process is not optional. IRS or state agents cannot sidestep it, even in collection. Redfield v. Fisher, 292 p. 813 Oregon, 1930. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. Bombshell. Corporations are created by law and taxable by license, but a natural person's existence is not a taxable event. Cohens v. Virginia, 19 U.S. 6 wheat. 264, 1821. The Constitution is a law for rulers and people, equally in war and in peace. Use. Government cannot claim emergency powers to override tax limits, rights, or the need for consent. McGrain v. Doherty, 273 U.S. 135, 1927. A statute must not invade the domain of constitutionally protected rights. Tax law enforcement that crosses into property seizure, excessive penalty, or suppression of protest equal void. United States v. Bishop, 412 U.S. 346, 1973. The requirement of willfulness is not met unless the taxpayer acted voluntarily, purposefully, and with specific intent to violate the law. Huge. IRS prosecutions require clear, voluntary, knowing participation in the tax system. Presumed liability equal not sufficient. Commissioner v. Glenshaw Glass Co., 348 U.S. 426, 1955. Income is defined as undeniable accessions to wealth clearly realized and over which the taxpayer has complete dominion. Use. Not all money is taxable income. Only that which meets the full standard. Not wages. Not barter. Not labor directly exchanged for compensation. Brush v. Commissioner, 300 U.S. 352, 1937. Compensation for labor is not profit. Direct hit. This supports the argument that wages are equal trade, not taxable gain under income tax law. Summary. Sovereignty tax subject. A natural person is not a corporation. Wages profit. Existence taxable event. All taxation must be within original constitutional boundaries. No consent equal no jurisdiction equal no lawful collection. Quotes from the team. Final dispatch. George Carlin. They don't want a population of citizens capable of critical thinking. They want obedient workers. The owners of this country know the truth. It's called the American dream because you have to be asleep to believe it. Thomas Jefferson. When the people fear the government, there is tyranny. When the government fears the people, there is liberty. To compel a man to furnish contributions of money for the propagation of opinions which he disbelieves is sinful and tyrannical. Noah Webster. In selecting men for office, let principle be your guide. Regard not the particular sect or denomination of the candidate. Look to his character. The moral principles and precepts contained in the scriptures ought to form the basis of all our civil constitutions and laws. Ludwig von Mises. Government is essentially the negation of liberty. Whoever wishes peace among nations must seek to limit the state and its influence most strictly. Doug Stanhope. Your job is just something that keeps you too tired to do anything else. If you're not necessary in a disaster, you're not necessary. Rick Sanchez. Don't break your back for the system, Morty. Build your own damn portal gun. Sometimes science is more art than science, Morty. A lot of people don't get that. Alexis de Tocqueville. The surface of American society is covered with a layer of democratic paint, but from time to time one can see the old aristocratic colors breaking through. The American Republic will endure until the day Congress discovers it can bribe the public with the public's money. Patrick Henry. Give me liberty, or give me death. The Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government. John Adams. Liberty, once lost, is lost forever. A constitution of government once changed from freedom can never be restored. Liberty, once lost, is lost forever. Final thought. They redefined you into silence. They licensed your liberty. They asked if you understood, and you nodded. But now you speak the old tongue, and the spell is broken.